Hi, everyone. Just waiting for people to come in. Where is everybody? I'm probably catching some of you at dinner time, but I want to just tear off the Band-Aid and get through this one. Hey, Emily. Some of you are starting to come in. My Christmas lights are flickering. It's making me look a little weird. Sorry if I'm catching you guys, some of you at a bad time. Like I said, I was just saying that I just really want to get this one over with because I hate bad news. I hate when there is bad news. I hate when I have to explain bad news. Just sucks in general. I'm still waiting for more people to come in. There's only about 20 people. So, but yeah, I mean, it's been, what a day. I actually, on top of all this, drove to the Court of Appeals or the clerk's office, because history has shown that it is a lot harder to get a copy of anything the state files than when KZ files something. And so I figured, well, it's Friday, and Monday and Tuesday are going to be holidays. And so if we don't get it today, we're not going to see it for a while. Obviously, didn't know at the time that they were going to rule on it right away. And I wish I could have waited a little longer to see if anybody else was going to try and get it. But I had company coming. My husband's friend was coming over, and I had to cook dinner for them. So I really just had to make a really impulsive decision to go. And right when I pulled up to the courthouse is when I saw that the screenshots, or when I was told that the screenshots have been released. So I was like, bummer. But no big deal. Not the end of the world. It's not that far of a drive. I'd rather, it's one of those, I'd rather be safe than sorry, because I know this is something I wanted to see, so I know everybody else wanted to see it as well. And again, at the time, I had no idea that they were going to rule on it so quickly. So, oh well. The funny thing is that I actually, again, I think I've said this before in one of my Zip videos. It might have even been the last one. I didn't sleep again last night. So on no sleep, I drove to Madison and then came home and cooked dinner and ate. And now I'm doing this. So I have no notes at all this time. I just didn't have time. I can already warn everybody that I am going to be going off on some tangents. I'm hoping they will all be part of the same cohesive unit, but I know I'm going to be going off on some different tangents just because it's actually a very complicated issue. And I always say it's interesting because, of course, it's interesting to me. I don't know if it'll be interesting to anybody else, but this is a lot more complicated issue than, it would seem on the surface. It was interesting to me that you could have an 8-page motion that would really be very thought-provoking overall. I'm a little frustrated with myself because I should have seen this particular thing coming. I think I was so focused on trying to figure out what Kathleen was doing with the discretionary reversal arguments that I wasn't considering what was kind of the most obvious hurdle to overcome, and that was just the basic procedural issue. So the first thing I do want to get out of the way is that this is a procedural issue. Okay. The Court of Appeals did not deny any testing. Okay. They were strictly ruling on whether she could remand the case, stay the appeal, and remand the case back to the circuit court in order to file a motion with the circuit court in order to do the testing. Okay, so this was not a denial of the testing, first and foremost. That's important, okay, because Kathleen can still request this testing at a later date, just when it's back in the circuit court, okay? In the motion, they mentioned the 2 ways that can happen, and obviously the most obvious one is that to get through the appeal. Finish the appeal, get a new judge, and then file another request for more scientific testing. No big deal. The other way that the state so kindly pointed out multiple times was that, well, Steve could just drop this whole appeal, feel free to dismiss it, and then you can go present this to the circuit court right away. Yeah, no need to be jerks about it. Clearly, that was not an option. So they were just being, they're just being idiots for even like suggesting that, because it's clearly not an option. It's not what she's going to do. Yes, she's been working on this for the last 3 years so that she's just going to forget all these arguments and put everything on this one issue. Not going to happen, especially when she can still bring this up at a later date. Now, one thing I want to mention is that when I first found out about her wanting to do this rapid DNA testing, I thought that she was actually going to be including it as part of the brief. The reason being that, and this is kind of key, what's kind of one of the key points to this whole thing, and why I didn't think of it earlier, or why it didn't dawn on me earlier, is why I'm annoyed with myself, because I already knew this. I thought that Kathleen was just going to present, or not present, but going to mention that this was a type of testing that she wanted to do once the case was remanded back to the circuit court. The reason why she could mention it is because she would have basically an entire subsection of the brief would be on her previous scientific testing results, along with, since she mentioned in the motion to vacate the previous agreement, that's part of the record, so she could bring that up in there. And I figured that would be the time when she would probably mention this, like kind of we would also like to do this new DNA testing on these bones that were found in the quarry. The reason that she could say that is because the actual testing itself, or even bringing up the testing, is not new evidence. That's why it can be added in the brief. Okay, and this is what's kind of important, is that the testing itself is not new evidence. It's the results from the testing that would be newly discovered evidence. Okay, the reason that's important. I'm going to jump around because I'm not sure how to get to A to Z in a very cohesive manner. So that's why I say I'm going to jump around a lot. Okay, let's start with just what the state was arguing. And they were saying that a 97407 motion, which is the motion for DNA testing, is a separate procedural mechanism that you can bring as an action in the circuit court. Okay, it doesn't have to be attached to any other motion. It can be presented anytime after conviction. And those of you who have been following the case for a long time, I'm not scrolling to look at comments right now. I'll try to catch up with them later because I wish it would just scroll automatically. It doesn't though. But yeah, while I'm talking this, I'm going to lose my place a million times. So not looking at comments right now. Sorry. I'll try to get to them later. Okay. So the 97407 is, like I said, is a separate issue. It's a separate mechanism, okay, for filing an action in the circuit court. Now, again, those of you that have been following the case for a few years will remember all the way back at the end of August, beginning of September 2016, that was when Kathleen filed her first motion for scientific testing. Okay, that was the first thing she filed. Well, not technically the first thing. She filed the motion to stay, I think, first, but whatever. So why she had to do that was because she obviously wanted this testing done, okay? But in that motion, she said that she wanted this testing done and that she planned on presenting the results in a forthcoming 97406 petition for post-conviction relief. First, you do the testing, and then you present it in the post-conviction motion. Okay, that's important because that's essentially what the state is saying she's not doing this time. We are in the middle of an appeal on a 97406. That is what's under review. That petition is what's under review. And so the state was saying that you cannot have a separate action filed for 97407 or 97407 for DNA testing within a 97406 that's already pending appeal. That would be something that you would do in the circuit court and then present a new 97406 with that information. Okay, the reason why is because a 97406 petition, okay, is a post-conviction petition based on newly discovered evidence. And those of you that watched my last video, remember that I made kind of a point of this, that I wasn't quite sure why Kathleen was making the argument for discretionary reversal as opposed to newly discovered evidence, which is what a 97406 was. That's what was confusing me, and now I know why it was confusing me, because, you know, she can't present it as newly discovered evidence because, again, the testing is not newly discovered evidence. The results are, and there's no guarantee that those results were going to lead anywhere. And so they were saying that under 808075, that statute is specifically with regards to what actions are permitted while an appeal is pending. And one of those actions is a motion to remand. Okay. So what the state was saying, that in subsection 5, it says that the court can use its discretion to remand a case to review a specific issue. Okay. They use the example of, or they use a different example, I think. I don't know if they mentioned the CD, but that's what happened with the CD. The CD was part of an existing issue that was already under review, and this was information that was going to add to an issue that was under review. It's essentially more information that may be necessary for the court to reach a decision. The testing would be a new issue that was not already brought up, that is not part of the 97406. So that was essentially what they were saying. They're saying that if you want to bring this motion, then you either need to dismiss this one, or you need to wait until it plays out and then it's back in the circuit court. And again, this is why that's what I thought she was going to do in her brief. I was surprised by the remand because of that fact. Then when I thought about it, I just figured, well, if she's granted the remand, it's a very short delay because it's a rapid DNA test. So it wouldn't really take a long time. Somebody just asked the question again. A little while ago, I answered it. And I said that before Kathleen files her brief again, if she wants to add anything new, she has to ask for a motion to remand. And I said this before, I said, but apparently I was wrong. But again, I wasn't thinking about this specific issue that they're talking about. I shouldn't use that term since that's what they're saying it's not. But I hope you know what I mean. Totally lost my train of thought. Again, I keep doing this. Oh, why do people message me? That I thought that it would make more sense to just add it as part of the brief to let the court know you want to do this, but that you're not going to be taking too much time away from, the appeal moving forward. And that's one of the issues that the state made too. One of the claims that the state, or arguments I should say, that they made too. They said that this case has been in front of the Court of Appeals for over a year and we've gotten nowhere. And I can, and it's a valid argument. It really is. We might not like it, but it is a valid argument. The courts are all about, keeping the process moving and trying to get to some type of finality. And so unless there seems to be something that is important for the court to know in order to decide the issues already in front of them, they are not going to remand the case. This was a completely separate and new issue. And as I said before, that this was the way she did it originally. She did the testing first and then got the results, and then the results were put in the 97406. Okay, it wasn't a request. The testing request was not made in the 97406 because that's not the proper form to make that request. It's a separate statutory procedure. That's stating it as simply as I can. Now, this is where I'm going to get it's going to get confusing. Okay, so when I read the state's argument, the first thing I thought was, well, this explains why she was arguing the discretionary reversal arguments. She was trying to stay away from the newly discovered evidence arguments. And I think that's why. Because the minute she starts arguing it as newly discovered evidence, that means she's trying to add this to the 97406, which that statute, again, is a separate procedure. That's not how it's supposed to be done. So by making these discretionary reversal arguments, she kept kind of hammering home the whole, this should be ordered because it's in the best interest of justice. Okay, he deserves a new trial in the best interest of justice. And she kept pushing that issue, kept pushing that issue. And I had said in my last video, I said I didn't understand why she didn't file or make the argument for newly discovered evidence, since that's what the 97406, and that's what was confusing me. And it turns out she didn't do it because she knew that wasn't procedurally the right way to do it. That she knew that, like I said, it wasn't the proper procedural mechanism. I hate to keep using that phrase, but there really is no better way to say it. That's just the way to say it. I don't know. So then it made sense to me why she was making these discretionary reversal arguments, essentially trying to get around this procedural issue by saying you have the power to order this because it's in the best interest of justice. Okay. And the more I thought about it, I was like, okay, there's something that Kathleen didn't do that I think might suggest that she knew she was kind of in a not quite black and white area. I think she was trying to create her own gray area to get around this issue. And again, this is completely a guess on my part. Just looking at the steps, looking at the arguments made, it makes sense to me logically that this is what she was trying to do. The interesting thing, and I did notice it when I read the last motion, I just didn't mention it because I just didn't realize that it might be important. And again, I don't know if it is or not. You know, this is why I say I'm not an expert on this. This is just what makes sense to me. And if you hear me explain it, you say, oh God, that does make sense. Well, then great. Okay. But don't take it as 100% certainty. Nobody knows what's in Kathleen's head. Nobody knows what she's actually doing for sure when she files these things. You kind of have to just guess, you know, what her method is. And I said that before. I said, I know there's a method to her madness. I just couldn't figure out exactly what it was because it was an odd way to argue it when the petition in front of them was all based on newly discovered evidence. So I was just like, why is she making these discretionary reversal arguments? Okay, so one important thing about that, though, is that Kathleen never used the phrase discretionary reversal. She also never cited the statute, which is unusual. And again, I didn't really think about how unusual it was until I kind of started putting these all together. I believe, again, my opinion, I believe she purposely did not use those words because in the title itself, discretionary reversal, it suggests, not even suggests, it states outright that you're asking the Court of Appeals to use their inherent authority, their discretionary powers, to reverse something the lower court did. They never heard this motion, so they never gave, the circuit court never gave an order or a decision on this motion. So it probably doesn't fall under discretionary reversal, which is why I think she might have just tried to avoid using that term and just kept focusing on in the best interest of justice. The controversy has not fully been tried. You know, she kind of kept pushing the issue as of, come on guys, look at all of this. You know, you cannot tell me that when you have all of these questions that it doesn't undermine the confidence in the verdict. And which is one of the standards. It says you cannot, how can you be confident that the verdict is correct when there are all of these questions? So I think that's what she was kind of going for. And again, the fact that she left that phrase out and actually left the statute number out, it leads me to believe, I don't want to say it tells me, but it leads me to believe that Kathleen probably had a good idea that this was not going to be granted. I think she anticipated the state's arguments, which is why she stayed away from the whole newly discovered evidence thing, to try to distance it from the 97406. And I think she didn't purposely use discretionary reversal, even though, trust me, those are the exact arguments she made. I think she even quoted the statute. I was going to read it again, and I didn't get a chance to. I think she actually quoted the statute without actually saying what the statute was. Because, again, that statute is for reversing something. And they weren't really going to be reversing something. She just wanted them to say, guys, you've got the power to do this. You can do whatever you want. That's what discretionary authority is, that you can do whatever you want. So I just want you to kick this back to the circuit court and order this testing because we feel like it's important and that it's in the best interest of justice, clearly. So once I read the state's motion and I started thinking about it, I had my whole drive home, I'm like thinking this through, and I was kind of like, oh yeah, I think I know now, finally know why she made that argument. But again, it also, when lawyers leave things out, there's a reason. There's always a reason. So I again, this is just a guess, and I could be so far off base. I don't know, but it's weird. It's strange to not list the statute number and not actually mention what the statute is in your arguments. And so I think that she's just trying to, like I said, create a gray area there. Where it's like, you don't have to actually be reversing something. You can just be saying that this is not right. We don't believe that the controversy was fully tried. We no longer have confidence in this verdict because of all these issues. So I think that's what she was going for. And again, the more I think about that, the more I think that she probably knew that it was possible that it was going to be denied. Which means that it's another one of those situations where she could just be trying, hey, I'm going to try to get it in if I can, knowing that it wouldn't delay things very much. The brief was due the 20th. It's the 28th now. Now they said the brief is due on February 1st. I am the first one that is always saying that attorneys don't file early. They just don't do it. This is a situation where it's possible because the brief was ready to go before she filed this motion to remand. She can't add anything new. She's not going to file another motion to remand. But there's still the reason why lawyers don't file early is because you never know when something new is going to come up, whether it be new information, new evidence, new case law, anything. And so you always want to put your best foot forward. So you want to make sure you're covering everything. And that's usually why they wait. But I don't really know in this case if she will or not, because, she needs to get this appeal going. That's why I said that, unless it's something huge, she's not going to want to remand it. We have to get through this appeal obviously to get an evidentiary hearing, but even more so to get rid of that judge. Everything is going to continue to be ruled on by Judge Suckwitz as long as we are in the middle of this appeal. And good Lord, do we need to get rid of that woman, okay? But I just wanted to make sure that everybody understood that this was a procedural issue. It says nothing about whether she can get this testing done in the future. I don't think it's time to lose faith in the Court of Appeals at all, because this was not a discretionary, it really wasn't a discretionary issue. It was a procedural issue, so it wasn't like they're saying like, oh, we just don't want to do this. No, the statutes are kind of clear on that. And, oh gosh, I had all this stuff in my head that made a lot more sense. Now, I know this is one of my tangents, and then I'll look through and scroll through for questions. I know I'm forgetting things. Okay, here's something that's always kind of bothered me. I know that people, when I say people, I mean guilters, are always saying that, like, why did she file an incomplete petition to begin with? Why is she changing her theories as she goes? Why is she just pulling new information out and then all of a sudden she's changing the entire timeline? First off, she's entitled to. Secondly, Kathleen is not only acting in the capacity of attorney. She is acting in the capacity of investigator. Okay, even if it's, she has investigators that are doing, the legwork themselves, she is still acting in the capacity of an investigator. When law enforcement is investigating a crime, it is perfectly acceptable that when you show up on a crime scene, whatever initial thoughts you have, or maybe theories, hypotheses, whatever, it's going to change. As new information becomes available, you're going to change your theories on what happened. You're going to have suspects that you're going to clear. Kathleen has done the same thing. She's had, a list of suspects, and then as new information becomes available, she's clearing them. Okay, so it's kind of a just dumb argument to say, like, well, she can't change it. Yes, she can. She's investigating. This is a fluid investigation. Okay, she's not presenting these different theories just because, like, oh, I'm just going to throw everything at it and hope it sticks. Sometimes lawyers do that. I've seen her do that before, but that's not what she's doing. She's following the evidence. Okay, she's presenting the theories of the crime based on what evidence she has at the time. Okay, now this is why this is a very unique situation, because it is not common to have a case be at the appellate level and still have new information coming in. It's almost unheard of. Okay, usually what happens is that whatever post-conviction testing, investigation, whatever you need to do, you do all of it, and then you file the petition. Kathleen's in a very, very difficult position because the investigation is fluid. It's been constant for 3 years. She can't just sit back and wait and say, well, when am I done? Because she doesn't know when she's going to be done. She'll be done when she gets Steve out of prison. She doesn't know when that's going to be. And then you also have kind of a chicken and egg situation where Kathleen will investigate, she'll find out some new information, she'll put it in a filing. Well, her putting that information in the filing will then lead to other people all of a sudden saying, hey, I know about that, or I know something that I didn't realize was important. But if this is important, then I know something, and then coming forward. People are realizing years later that they know things that they didn't even realize that it mattered. So her filings then are leading to more tips. Well, then more tips are leading to more filings. And it's a vicious cycle that is not going to end. So again, the detractors are saying, like, well, she shouldn't have been filing this stuff earlier. She can't just keep filing. What else is she supposed to do? Okay, she just can't sit there and say, like, okay, I'm done. It's not that, like I said, until Steve's out, she's not done. And as long as she's getting new information and new tips, she has to keep compiling that. She has to keep working the investigation. And anybody that says I'm wrong, well, I was an investigator for several years and I worked for attorneys. And I don't think there was ever a situation where I walked into a situation and my initial impressions were anywhere near what they were after I actually started, investigating and getting more information. So that's why things are changing, and why it's, like I said, again, it's not like she's going to say, like, oh, this just sounds better. No, I mean, she's learning new information, and that changes the perspective of things. Okay, and so that's why we're having this issue where it's had to be remanded, and that's why, even though I say that, Kathleen's the one that's been dragging this out for a year, she has to. She doesn't have a choice, because stuff keeps coming up. And her job is to present Steve's best case. And so I just wanted to touch on that, because I know I see that a lot where people are just, I'm like, stop looking at it through bias of thinking Stephen Avery's guilty. Stop looking at it as bias that you don't like Kathleen Zellner. Just look at it from the very logical standpoint that when you're investigating something, things change. You learn different things. You learn about new suspects. You get clear old suspects. It happens all the time. And it's not any different just because this is a lawyer that's involved. She's just in a much more difficult position because she doesn't have the luxury to wait until, like I said, it's done, because she never knows. She never knows when the information is going to stop, is dried up. She's always going to be constantly trying to find more. Okay, so I had to get that off my chest because it is tied in. Like I said, it's tied in with this whole newly discovered evidence, and why are we asking for remands? Why is there new evidence still coming out? Again, it's not like she's trying to be, drag it out forever. It's just what's happening. Okay, I'm going to look at some of the questions. Justice, stop. Ashley, come get her, please. If you can, hon. Of course, I think my daughter has her headphones in. Can't hear me. Figures. Hey, Lacey, I use my Instant Pot too. I made beef stroganoff in the Instant Pot tonight. Okay. Right. Julie's just saying we can take a deep breath. And that's what I was actually going to start the video. Okay, deep breaths, everyone. It's a setback. Obviously, ideally, it would have been nice if they would have ordered this. We get this testing done, and but the thing that I know that people struggle with, and that is why people are always so willing to say, oh, they're all crooked, it's all corruption, whatever, is because it doesn't make a lot of common sense. Okay, and well, you know what? The law doesn't. And just like I said in the last video, when I said that in general, we're happy the laws are the way they are. It's not, the law isn't meant to make it easy for people to get out of prison. It's not intended. We want it to be difficult for people to just file, an endless stream of frivolous appeals and post-conviction motions. We need these rules in place. It's just that when it's for somebody who's wrongfully convicted or trying to prove that they're wrongfully convicted, it can be very, very frustrating. But I said, this is not, and I said, and one thing I know, because I know I'm going to see it, is that people are going to say they denied the testing. No, they did not. They did not deny any testing. They just denied her being able to remand it to do it now. They're saying, we're going forward with this appeal. We're going to get through this. And, the Court of Appeals could still very easily, and they should, order an evidentiary hearing, and then she can order the testing then when it's back in the circuit court. No problem. So it's one of those things that would have been nice, but it really isn't the end of the world. And it's not any grand statement about the Court of Appeals. Again, completely procedural. That's it. Simone, I'm sure you realize by now they did rule on it already. They denied. The bottom line is that, well, I think I put it in my post today. I just said that really all this does, it means that the appeals moving forward, we're right back where we were when we were waiting for it on December 20th, only now the due date's February 1st. But it's going to be all of the issues. Now, what's going to be in there, I think I talked about this last time, but it's going to be the original petition for post-conviction relief. It's going to be the motion to vacate, all the motions for reconsideration, and all of the amendments and supplements that were added to that. And then the amended motion when she did the remand for the CD. All of that is part of it. And that's all that's going to be reviewed. So we're going to see, why is the brief now due on February 1st? Well, normally they give them 40 days. Is that 40 days? I don't think so. I don't think it's quite 40 days. I'd have to count the days to see if there was any specific reason they gave that, or if they just thought it was a nice round number. Because normally, anytime there's a decision where the Court of Appeals is ruling on something, they'll give them another 40 days. But let's say if we're talking about 3, and then January 31, that'd be 34. So we're talking 35 days. I just thought 35 days sounded good. I don't know. Or they could be tolling the time. No, because that would be 8 days from the last one. I don't know. Who knows? Doesn't matter. It's just bonkers. Yeah, the law often is. And it's very sad because, this happens all the time. Procedural issues prevent fairness a lot. And that is one of the arguments that Kathleen made in her, in her motion. She kept saying that it's fundamentally unfair. The investigation, the trial proceeding was fundamentally unfair, and therefore conviction should be overturned in the interest of justice. Again, she really focused on that. And like I said, I'm just glad that now I think I at least have an idea of why she was making these discretionary reversal arguments, because it was just an odd thing to do, but she knew what she was doing. Okay, Rich, I think there's an accumulation issue. How can there be so many things wrong and there's no reason to investigate further? By investigate further, I mean have an evidentiary hearing. Well, again, I mean, the biggest issue, I've talked about this before, but I know I have a lot of new people. Judge Suckowitz didn't even consider about 70% of the petition. Okay, and she made errors on some of the things she did consider. So she's basically useless. So the reason she didn't consider so much of the petition is because of what's called procedural bar. And I apologize to you, of those of you who have heard me mention this so many times. Technically, a 97406 petition was intended to be a one-time deal, a one-time shot. That's why I said in most cases they do all their investigating, all their testing, and then they present it all in one motion. And that it's, again, it's supposed to help with, finality, help promote finality of a case. In Steve's case, he filed a 97406, which is considered a collateral attack. It's not an appeal per se. It's a collateral attack. It's something you do after a direct appeal. Okay, if you failed on direct appeal, then if there's newly discovered evidence, then you can file this 97406 post-conviction motion. Steve filed one pro se, meaning he didn't have any attorneys helping him. He filed it on his own. It was denied, and Steve was in the middle of that appeal when Kathleen signed on. She filed a motion to stay that appeal until she did the scientific testing. Once she did the scientific testing, she ultimately had to dismiss that appeal. Okay, she dismissed that appeal, and she ended up filing a new post-conviction motion with all of this newly discovered evidence. And one of the things in order to overcome procedural bar is that you have to provide sufficient reason as to why these issues weren't brought up earlier. And Kathleen did. She said, well, first off, Steve's case is, 50 boxes, or how many, not 50, I think it was 20 banker's boxes of files and documents, and he's only allowed to have a few in his cell. I can't remember the number now. God, my brain is just going. But, essentially that he's not allowed to have all those documents in his cell. How can he possibly be researching this case like he wants to when he doesn't even have access to all the information? And then she brought up the fact that it's unreasonable for the court to feel that an inmate, especially one in indigent circumstances, doesn't have any money, how he's supposed to not only investigate, but hire experts and all the things that she is capable of doing. That, she was trying to make the point that a person shouldn't be punished because they don't have representation. They should be punished because they don't have any money. And you really shouldn't be able to use the argument against them that, well, they shouldn't have filed if they didn't have counsel. Well, because in Steve's case, he had no idea he was ever going to have representation again. Was he supposed to wait forever? Nobody knew what was going to happen after. Nobody knew Making a Murder was even going to come out, first off. And then when it came out, nobody had any idea what was going to happen. And he certainly didn't know that Kathleen Zellner was going to be his attorney. So you shouldn't fault somebody for wanting to advocate for themselves. But Judge Sekowitz, and there were other arguments too. One of the other things is that if you can not only provide sufficient reason why they weren't raised earlier, and if the arguments you're making in the current petition are stronger than arguments that were made on direct appeal, the previous post-conviction, and on the previous 97406, you should be allowed to present it. And again, she provided list by list, step by step, why her arguments were stronger than the previous ones made. And that's one of the issues that the judges completely ignored. So the judge said that because he'd filed this previous motion, he was procedurally barred from presenting all that. It's considered, those issues are considered waived. They're saying if you didn't bring it up before, then clearly then you're waiving that issue and you don't have a right to bring it up again later. And again, the spirit of that law is that people don't keep trying to relitigate the same issue over and over again. But that's not what that law does. It prevents them from bringing up other issues that they may not have even known that were issues at the time. And that's why there's a real problem with that part of the law, is people don't know things until they know them. It shouldn't really matter whether, they should have through due diligence, known about it 5 years ago. So that's why the judge didn't consider everything. She's saying that it was all procedurally barred from being presented. And that is ultimately what I think is going to get her decision reversed. It's because she didn't follow the law. That was another tangent. I told you I was going to go on a bunch. Be so many things wrong. So anyways, so that was the reason, Rich. That was my long way of saying how going to be so many things wrong. Well, because she's not even acknowledging them. She's not even looking at those issues. Hopefully the Court of Appeals will. Okay, Missy, lots of speculation. Can you address the timing of the judge's decision? I admit I was completely surprised with how quickly it came down. I had actually just got done telling somebody that, I said Kathleen will file a reply, because every time Kathleen has filed a motion, the state has filed a response, and she's always taken the opportunity to file a reply. So I figured she was going to be able to file a reply, and nope, they just responded right away. When I first saw that the state responded, I kind of thought, well, they were kind of lucky because the court could have ruled on this already. So how did they know they weren't going to rule on it? Things like that, I do admit, are possibly suspicious, but you can't make any, you can't draw any factual conclusions from it. You can just say, hey, it seems a little fishy to me. But it could be perfectly, you know, I mean, there was a holiday, whatever, you know, it just, I mean, it was a 9-page motion. The motions judge could have got it, read it, and been like, yep, that's the right argument, and that's been it. I mean, and it could be that simple. So, I mean, it wasn't like a terribly lengthy motion or anything. The law in it, the statutory law in it, was very straightforward. So there really wasn't a lot for them to consider at that point. If they'd already read her motion and knew what all her arguments were, then, you know, then they really didn't need to spend too much time on the counter argument. New information is a pain in the backside sometimes. Yes, it is. She's doing what investigators should have done. Yes, she is. And it's amazing how much she's found this many years later. Think of how easy it would have been if the investigators then would have actually done their jobs. Right, Mark. And yeah, more, you know, her job is to show fault in the ruling. More than one theory seems plausible to me. And the other point is that she doesn't have to, you know, none of her theories have to be correct. You know, she just has to prove that it's possible that one of these other theories is a possibility. Again, her burden is not as high. You know, the clear and convincing evidence is the burden in a petition for post-conviction relief. Okay, it's not beyond a reasonable doubt. It's clear and convincing evidence. And I believe there's enough for clear and convincing evidence. So it's why Kathleen's always saying, I don't have to find the murderer. You know, I'm not even, you know, like, I'm not gonna say she's not trying. It's just that in this situation, when there really is no obvious DNA that can exonerate him, I think she feels like she might have to. You know, she's certainly going to keep trying. Jesse is looking for justice. You use the Instant Pot too, Andy. What would we do without that thing? Could appellate court rule Brady violations occurred, making testing moot at this point? Well, that's something I talked about in the last video too. The circuit court or the Court of Appeals certainly could rule on any of the merits that were presented. I think it's possible they may sort of punt on the merits and just say that she made an error of law and kick it back down to the judge to say, you need to actually consider this entire petition and rule on it properly before we're going to do anything about it, or before we can review it. We can't review when you didn't do anything. So they could do that. It would be nice if they were just like, oh, we're just going to bypass you because you're dumb, and we're just going to order the evidentiary hearing. I think the hope is that there's enough there outside of even the procedural bar issue with the scientific testing that that they would say, like, yeah, there's enough here to warrant a hearing. And again, a hearing is necessary because it's necessary for both sides. It's not just for Steve's benefit. It's necessary to get to the truth, period. You have all of this evidence that doesn't add up. You have all these questions. Well, that's what a hearing is for. Because right now, Kathleen's only hearing from one side, or just like whatever is coming to her. She has not been able to get any of these, you know, officers on the stand or Kratz on the stand, you know, so that is going to make a big difference in how things go. And she should be entitled, well, Steve is technically the one that's entitled to it, but as an attorney, she should be entitled to get these answers, or try to get answers to these questions. A lot of people just saying hi. I'm glad everyone's so friendly. How does she get rid of Judge Suckwitz? Just like I said, she's got to get through this appeal. That's why I said that she can't remand it anymore, because she's never gonna get rid of the woman until then. What do we know about the panel judges? Overall, actually, none of them seem to really have a bad reputation. There's 4 judges in the District 2, and Gunderman is going to have to recuse himself. He won't be allowed to be part of the panel. So that leaves you with Neubauer, Riley, and Hagedorn. God, why can't I say her name? Neubauer and Riley were actually part of the panel of Steve's previous direct appeal. But the fact that they denied him really is not indicative of anything, because it was a terrible appellate brief. Steve's post-conviction and appellate attorneys did him no favors whatsoever. It was terrible. The thing that Steve's public defender, appellate attorney was best at was asking for extensions. She seriously asked for extensions for like 3 years. Maybe not that long, but close to it. And then she put together a pathetic brief. So I will definitely not hold it against Hackett. I mean, I'm Riley and Neubauer that they denied that appeal because it was quite frankly just awful. I could have done a better job. No, the Court of Appeals is in, well, okay. The clerk and the offices, administrative office for the Court of Appeals is in Madison. Each actual courtroom in the Court of Appeals is in a different location based on the district. Manitowoc is in District 2, and that courthouse is actually in Waukesha County. That's the Waukesha County Courthouse. Chicago, that's the U.S. Court of Appeals. That's federal. We are in state court. Okay, you guys, stop with the chit-chatting. I got to get through these. I can't find any questions. If they order a hearing, who would hear the hearing? Oh, I don't know if I should say this or not. Okay, all I'm going to say, I don't know what I can say and what I can't say, is that based on Kathleen's previous motion to substitute judge, is that she is going to be asking that the case be put back in Manitowoc County. I know it sounds crazy, but she has her reasoning, as always. But yes, I would believe that she's going to try to get it back in Manitowoc County, based on her previous motion. How are you, Tracy? There's a question. I didn't realize I was that close to the end. Otherwise, you guys can always chit chat. That's fine. I've had quite the day. I didn't sleep. And then I saw there was this response. And then I drove to Madison to get the response. And then I rushed home, immediately made dinner. I may or may not have read the response in the car. Don't tell anyone. And then I scarfed down my food and I sat down and did a video. It's been a busy day. I'm surprised I'm still functioning at this point. Let's see, what other questions? Schimmel going to Waukesha. But again, Schimmel's a circuit court judge. He'll be a circuit court judge in Waukesha. It has nothing to do with the Court of Appeals. The Court of Appeals judges are still, they are located in Waukesha County in that courthouse. So nothing to do with each other. Hi, Tammy. I assume who's the high beautiful lady at? Look at me. I don't know. So you guys really, considering how complicated I was thinking this was and how hard it was going to be to explain, and did I either just really confuse you and you don't even know what to ask, or did you actually understand this? And again, I have to stress not to air that. Again, I have no way of knowing what's in Kathleen's head when she does these things. Nobody does. I'm just trying to use some logic to try to figure out, the chess moves. And trust me, Kathleen is a chess player. She's always thinking several moves ahead. Well, you wouldn't need a change of venue right now. I mean, because they can ask for any judge or any court or county in the district. So a change of venue would matter if they ever tried to retry him. If she asked for a new judge, is there any chance at all Schimmel would be appointed as Waukesha? No. There'd be conflict of interest, first off. But no, I mean, like I said, Waukesha actually isn't in District 2. The Court of Appeals for District 2 is in Waukesha, but Waukesha County is not part of District 2. I don't think it is, or maybe it is. No, it's not. No, it's not. Why did I even second guess myself? No, District 2 is Manitowoc, Calumet, Sheboygan, Fond du Lac, and Winnebago counties. So all those cases that are in those counties that go to the Court of Appeals are in District 2. Waukesha itself is not in District 2. They said it's just where they house that courthouse. Why they wouldn't put it in one of those counties, I don't know, because they're all smaller counties maybe. I don't know. Again, they do weird things. You guys are still talking about food. Have I ever spoke to KZ? Would I? Well, of course I would. I've emailed her a few times. That's it. I actually was at the yard once when she was there, but I didn't talk to her. She was talking to Dolores, and I wasn't obviously going to go in there when she was doing that. So now we wait for the original brief to be submitted. Do you think KZ was just buying herself some time? No. No, this wasn't to buy herself time. I mean, she had a legitimate reason for wanting to file this remand. She doesn't need any more time for the sake of just buying time. If she wanted to buy time, she'd ask for another extension, you know. No, she can't add anything. I mean, I know we've said this to death. She cannot add any new information. The only thing she can present in the brief are things that were presented first to the circuit court. If it wasn't presented to the circuit court, it cannot be added to the brief unless she tries another remand, which I hate to say anything with 100% certainty, but my gosh, I hope not. How long for decision for the appeal? Okay, well, that's a good question. Thanks, Mark. Okay, Kathleen's going to file her brief. The state has 30 days to file theirs. They will ask for an extension, and before anybody freaks out, they're entitled to ask for one. Kathleen had a year's worth of extensions, and this is going to be 35,000 words, and that's not including exhibits. That's just the brief itself. Is going to be roughly about 115 to 150 pages, 115, 125 pages, something like that. It's going to be a lengthy brief, okay? It could be anywhere from, like I said, 150 to 150, who knows? It's going to be a lengthy brief. So they are entitled to a fair amount of time to present their arguments in response, okay? Again, we can't be as unreasonable as the other side is and also say, like, why are they asking for 90 days? Well, you know what? Kathleen asked for more than that, and there's a lot in there. So, you know, fairness, it has to be fair. Otherwise, you know, we want it to be fair. We just want it to come to the correct conclusion this time. But we don't want things to be unfair for either side. What am I doing for New Year's? I have no idea. I'll come up for a night or two. I'll see. We'll talk. Oh yeah, okay. Gosh, totally got sidetracked. Anyway, the state has to file their brief. They're also going to be delayed because there's a possible, you know, everything's changing. The governor and the AG are changing, so that they take their positions on January 7th. So there could be some delays with the changing of the guard as well. Now, you know, to be honest, the AG is overseeing this case just because Brad Schimmel's name's on it. I guarantee you Brad Schimmel's not the one that knows this case the best. Okay, the AAGs that work on it, you know, are the ones that know the case. Well, not in this case. These one, I think the attorney that filed this today has probably got up to speed compared to her response to the judicial substitution, which was awful. They've had plenty of time to get up to speed. So Josh Call would need to be up to speed, but he's not going to know every detail of the case at that point. He's going to trust the people that have been working on it, unless he gets rid of all the attorneys, but I don't see him doing that. And somebody said, is there any chance that things will change? Well, we'll find out when they file the brief, and if it's still the same arguments and the same everything, well, then we'll know. Probably not going to make a difference. And then after the state files their brief, Kathleen has 15 days to file a reply. Now, I know Kathleen said in an interview that then there will be oral arguments. If you paid attention before in my group when I was talking about statistics, oral arguments are not necessarily the norm in the state of Wisconsin Court of Appeals. They are in the federal courts. There has been one oral argument in a criminal case in 2 years. So it's not a given that they're going to ask for oral argument, or that they're going to order oral arguments. They could, because obviously it's a very complex case. So if there was ever a case where they might, want to have oral arguments, then this could be it. And yes, in general, they are usually open to the public. But again, with this case, you never know. They didn't close Brendan's proceedings, so they might not close Steve's. But again, that was federal. This is state, so they might close it. I don't know. But if there were to be oral arguments, then yeah, they would probably be open proceedings. But no, Steve would not be there. Not usually, anyway. I don't see why he would be. And then there's a decision. So if there's oral arguments, the decision is going to be much further out. If they decide the appeal on the briefs alone, then it would be about 4 to 6 months probably. So let's say they ask for, we're talking the state might not even file their response until spring. So we're talking already that it could be fall end of the year, even if there's oral arguments, it could be very end of the year before they make a decision. But honestly, there's enough there that they can make the decision on the briefs. Really, the only reason to have oral arguments is if you really want to, if you think you're going to rule on the merits and you want to explore a specific claim, very detailed. Yeah, I know. That's why I said people get excited and they see deny and they immediately, I was just responding to Julie's comment. I should say I'm more calm after listening to you. Like I said, people see deny and they just immediately get angry, and I get it. I totally get it. I understand it. But sometimes you have to just accept that, the law is the law and it doesn't always work in your favor. And more often than not, it doesn't work in your favor. It doesn't necessarily mean that there's anything fishy going on, suspicious going on. Sometimes it's just procedures are just weird. Same reason why Kathleen couldn't get a judicial substitution. Same thing. It wasn't because they're trying to beat her down. It was like, no, she didn't really have the grounds to file it. It's very clear in the statutes that you can't do that. So, okay, now you said inviting Angie too. So is Casey going to be able to get the bones tested? Well, I mean, one step at a time, but I mean, she can certainly make the request again once it's in the circuit court. There's nothing stopping her from making the request. We still have no answer on this whole bones issue, whether they have them, don't have them. It's a moot point at this right now. I mean, again, that's for Kathleen to deal with. If that's true, she'll figure it out. I have faith in her. I don't think she ever truly hits a dead end. I think she just will keep digging. She'll just tunnel right underneath until she gets to what she wants to get. So, but they certainly can make the request, and that's why that was one of the things I really wanted to make sure people understood, because I can already see it. I haven't gone to any other social media, but I can already see people saying they denied the testing, and no, they didn't. They didn't at all. Under the listings of District 2, Waukesha is in there. However, I absolutely thought it would be a conflict. Thank you. Okay. Is Waukesha? No. Why would Waukesha be part of? I don't know. Okay. It doesn't make sense. Waukesha should be district. Milwaukee County is District 1 all by itself. So I would think that Waukesha would be part of District 3. I would look, except for, I'd lose the camera if I go to a different tab. So I'll let you know. Yeah, because I'm pretty sure District 2 is all the counties I named. What in a nutshell is the brief state? Well, it's just what I said before. All the arguments, all the issues she presented in the original petition, and I can't do it in a nutshell. There's remember that brief was, or that petition was 220 some pages, and then all the motions for reconsideration. I can't list everything. A lot of IAC claims, ineffective assistance of counsel claims, some Brady claims, ethics claims against Kratz, which probably won't go anywhere. Yeah, just a bunch of stuff. Yeah, and it's funny how it's fair for the courts and not Stephen. And again, that's when I point out to people, though, the system is not designed to make it easy, because how 90-some% of people that are in prison are supposed to be there, and we really don't want them getting out on technical errors. So we want to make it difficult. It's just really bad. And I will say it again, I've said it plenty of times, but this is why I'm such a big fan of conviction integrity units, because it gives people who are wrongfully convicted or potentially wrongfully convicted a better avenue towards relief. They don't have to follow the same tedious appellate process that every other prisoner does. You actually will have another procedural mechanism in order to get your conviction looked at in a much timelier fashion, because conviction integrity units are created by the state, and they have the power to just drop it if they want to. The new person can't re-rule on their response. No. I mean, technically, she could ask the Supreme Court for a motion for reconsideration, but oh God, no. Or a petition for review, but she could ask them to reconsider it, but honestly, it would just be a waste of time at this point. Can KZ still work with the AG to get the bones tested? No. She can work with them. She can talk to them all she wants. They can talk to each other as much as they want, but no, because again, there's no mechanism for them to get the bones tested. They're not in the circuit court. And it doesn't matter what they agree on. They could both agree on every single point, and it is the court's decision. It is not the state's decision. It is not Kathleen's decision. It doesn't matter if they agree on everything, because that's kind of what happened with the agreement before. because Kathleen kind of said that, like, we agreed, and the judge was like, wasn't really up to you two. Only the judge can order evidence to be released and tested. Only way. And that's for, both sides. So now it goes back to the Court of Appeals. Well, it's never left the Court of Appeals. Well, it did when it was on remand, but it was still in the Court of Appeals jurisdiction. So yeah, it's never left there. I mean, that's where it's been sitting. I mean, it's in the Court of Appeals. She asked to get it remanded back. They denied it, so it hasn't gone anywhere. The record is still part of the Court of Appeals. Yes, it is heartbreaking. Oh, thanks, Travis. I still can't look at it. I can't click on it. Oh, you know what? Oh, God. You know what I was thinking of with the District 2? Okay, I know what I was thinking of where I was getting confused. Those counties I listed, those are the counties within the district for the circuit courts. So if they ask for a change of venue, those are the counties it can go to. That's why I'm confusing myself. So you're right. Yeah, that's why I was trying to figure out why would it make sense that Waukesha, it would be in a Waukesha court if Waukesha was part of District 2. You guys are right. Thank you. And that just refreshed my memory. I don't know how seeing a link refreshed my memory what I was talking about. Yeah, when they were doing the judicial substitution, a judge would come from one of those counties that I listed before, which makes a lot more sense. God, I confuse myself sometimes. Yeah, with Brendan, there's zero evidence. We all know that. And the one thing I've said a lot of times is that the judge ruled that Steve is procedurally barred from presenting these things on another petition because he already filed one. Brendan's never filed one. Brendan has never filed a 97406. So if he wants to file a petition for post-conviction relief at the state level, which he will, he's not barred like they're saying Steve is for a lot of these things. Yeah, one judge. That's why I said the motions judge. You only need one judge. That's why when you said, is it hard to get a decision, or is it strange that the decision was so quick? I said, no, the motions judge could have just looked at it, and it's 9 pages. And yeah, in general, motions are decided by one judge unless they decide to refer it to a panel. If Casey gets an evidentiary hearing, can she then test the bones? She should be able to, because it's back in the circuit court. So at least then she's in the proper court with the proper jurisdiction to be able to make that request. Once it's remanded back, there's a whole lot of procedural issues that are kind of fuzzy. So, but I think she should be able to. Yeah, Calumet, well, obviously Calumet, Manitowoc are in District 2 because otherwise his case wouldn't be in District 2 right now. But still conflict. Yeah, it's still a conflict of interest for Schimmel. But it like I said, yeah, it would never go to him anyway. Okay, but yeah, that's where it was getting confusing. Okay, the Court of Appeals judges, okay, are in the District 2 for the Court of Appeals. When they're picking a judicial substitution judge, it's in District 2 for the circuit courts. That's where the confusion. So that's why I was saying that the judge would have to come from Manitowoc, Calumet, Fond du Lac, Sheboygan, or Winnebago. We were getting the two confused. I think we were talking about two different things. That's where the confusion was coming up. The Court of Appeals is in District 2, and Manitowoc is part of District 2 to get the Court of Appeals heard. When you're talking about a judicial substitution, they could not get Schimmel because Waukesha is not part of District 2 for the circuit courts. Now am I making sense? I was trying to figure out why I was getting so confused. Now I know why. Because my original answer was that no, they couldn't get Schimmel because he's not in a county that's part of District 2. Or unless it's District 4 for the circuit courts, whatever district they are in for the circuit courts. When you're talking about judicial substitution, there's a chief judge for those counties that makes the decision about judicial substitutions, and she would be the one that would decide. And if Kathleen makes a specific request, then they should have no reason to deny it as long as it's in that district. Is KZ working closely with Brendan's lawyers? I honestly don't know. No idea. I'm sure they've talked at some point, but yeah, I don't really know how much information they share. Gotcha, Lacey. I knew we'd get there eventually. Well, Elizabeth, okay, that's one of the things that the Court of Appeals could, she's saying, can KZ get an evidentiary hearing anytime or after ruling on appeal? The Court of Appeals can order an evidentiary hearing on their own, or they could remand it back to the judge for her to reconsider those issues she never considered, in which case then if she's told you need to consider those, she may finally look at them and decide that yes, a hearing is warranted, or she could still deny them, and then the Court of Appeals would then rule on the merits and order an evidentiary hearing. I hate to even say that because it draws things out. It drags things even out. No, Travis, he said that Brendan's problem is issue preclusion for the 97406. Again, that's the same as saying that it's waived. Brendan's confession stands. So they, whatever was raised in federal court, whatever was raised on direct appeal, he's still barred from raising those issues again. Anytime something has been properly and, there's a finality to the litigation of a certain issue, you can't bring it up again. So if it was brought up on post-conviction, if the first post-conviction, if it was brought up on direct appeal, federal habeas, or another 9706, you can't bring it up again. So yeah, unfortunately, Brendan's confession stands. How can they deny further testing? Tammy, where have you been? That's what this entire video was about. I just said because there's no procedural mechanism for them to do the testing. And I said it's a procedural issue why they won't remand it for that particular issue. It's because it's an issue that's not currently in front of them in the current appeal. So, and again, I just said they didn't deny testing. That's the one thing I'm trying to get a point, because you said, how can they deny further testing? They didn't. They didn't deny any testing. They're saying you cannot do it right now based on where we are in the appeal, the motion in front of us, and what you're asking us to do. They're saying that's not the proper mechanism to get that done. You have to wait until the appeal plays out or dismiss it, which is not even going to happen. So, yeah, so that's, if there's anything anybody takes away from this, don't say that they denied testing, because they didn't. That wasn't the issue even in front of them. Hey, Becky. Yeah, it was just basically saying like, okay, you can give it a shot. We're trying to remand it because we'd like to get the testing done right now, but they can't. They're not saying she can't do it. Even the state said you're welcome to file the motion, later. They even said that. Just can't do it right now. Got to wait till you get to that step. Okay, so have we covered everything? Are there any other questions? It's already been over an hour. I get sick of hearing myself talk after that long, so you guys have to get sick of me. It's really hard for me to see when it says replying to somebody, so that's why sometimes the question might not be directed at me, but I'm answering it because I just saw that one was replying to Barb and replying to Becky. Yeah, see, I don't always see that. It's kind of small, so thanks, Travis. Okay, so, oh my gosh, there's like no questions, and you guys like all post like 10 at the same time. Court of Appeals seems reasonable, don't they? Did I just skip over that before when I said that Gundrum would be recused themselves? Yeah, well, I said, that the only ruling that has been against Steve was one on his direct appeal, which was the correct ruling because it was terrible. Hagedorn especially has really got a good reputation for being very fair. Neubauer and Riley have been around longer. Hagedorn's a little bit younger. But yeah, there's still, even despite this decision, there is still no reason to believe that we can't still have faith in them. Now, if they rule against him and deny this appeal, all right, faith gone. But until then, we still have really no reason. Just because this decision is, again, it's a totally different issue. It's a procedural thing. It has nothing to do with them trying to block her from doing anything or stop her from doing anything. It's more like, just can't do it that way. Yes, Tammy, you're going to have to start over. I don't want to go on for another 1 or 2 hours. You know how much I hate doing these things to begin with? I just could not figure out a way to type this out and explain it to people because I knew it was kind of going all over the place. I hate doing live videos. Anybody who knows me knows that already. Why do I think she has to wait to file a night? Because she's not in the circuit court. That was the whole beginning of the video, was talking about that. She's not in the circuit court, and it's a separate action. It's a separate issue, and it's not part of what is in front of the Court of Appeals right now. So remanding the case for this is a separate issue. They're not remanding it for something to give additional information to what they're already considering, which is why they would remand it. And again, like I said, this is something that is already known because this is how she did it last time. Right now, they're basically saying you're putting the cart before the horse. The way it usually works is you file the motion for scientific testing, and then you take those results and you put those results in the petition, because that's the newly discovered evidence. The test isn't a newly discovered evidence. It's the results from the test. And so that's why it's a separate procedure, or it's a separate statutory mechanism, is because, you don't know what's going to happen with it, or so you don't really necessarily know that it's going to result in any newly discovered evidence, which means that it couldn't be added to that. So they're kind of saying, like, why, it's just not a proper way to do it right now. I do need sleep. It's amazing how well I function sometimes, though, I no sleep. And I say no sleep, no sleep. Gunderman's connection, he was the one that worked with Steve when Steve was exonerated the last time on the Avery bill. And then he ditched Steve like a hot potato as soon as Steve was arrested again. For most of us, it seems like no hope. No, I mean, there is always hope. And Steve and I have talked about this plenty of times. He agrees when KZ is involved, there is always hope, because that woman will not give up, and she's tenacious. If anybody hasn't figured that out by now. And I think she's a woman that likes to win. I mean, get a lawyer that just flat out likes to win. And that's good for your cause. But when you have one that refuses to give up, there is always hope. Remember, Steve got out after 18 years last time. We certainly don't want it to go that long this time, but you see people every day that are, exonerated after 30 years. Well, we don't want that, but there is always hope. Michelle, I have to do these. Only when it's something complicated like today. And I was thinking in the car, I was like, this was seriously like an 8-page response. How did this get so complicated? No, she can't file in the circuit court, because I said there's only certain actions that are permitted to be filed in the circuit court during an appeal, and a 94707 isn't one of them. She can't file. The Court of Appeals has jurisdiction, so until the circuit court has jurisdiction, she can't file anything in the circuit court. The record is with the Court of Appeals right now, so she can't file with the circuit court directly. And every state's different, but in Wisconsin, that's how it is. I don't know how it is elsewhere. Get this thing out of Manitowoc altogether. And Michelle, that's why I was saying, though, it kind of surprised me that Kathleen wants if she gets a judicial substitution, she actually wants to take it back to Manitowoc. But again, not gonna question her. She knows what she's doing. Oh God, Dave. He's asking, what is Casey's best argument she has right now for an evidentiary hearing? I change my mind all the time on that, and I honestly would have to sit and think about it right now. I think the day planner is a big one. I think that's a big one. I mean, again, maybe there is another explanation, but you don't know until you have an evidentiary hearing. The stuff, with the computer, I mean, that's a big issue too. It's like, how are you ever going to get to the bottom of it if you don't talk to anybody, you don't question, Fassbender, and like, why the hell did, what happened? Where did this come from? Why didn't you do anything about it? I mean, those types of things, you have to get to the bottom of that. The CD, why wasn't the CD handed over? Why did Fassbender keep it in his possession? Those are all questions that need to be asked, and all of them warrant a hearing to get to the bottom of them. Colburn, was he there at the Senex station? Where was he? When was that phone call, the plate call made? He really, I mean, I know that was addressed during the trial, but it was not addressed very thoroughly. Oh my God, the day planner, biggest thing. Yeah, I mean, that's a pretty huge thing. I mean, because when you have two people saying she had it in her vehicle with her, and yet it was in Ryan Hilke's possession, it's, again, you can't say for sure that there is another explanation, but you don't know until it's more, sorted out. You get Ryan on the stand. That's the whole point of an evidentiary hearing, is so that, those types of questions can be asked. So you can get to the bottom of it. Again, it's supposed to be about getting to the truth. And getting, sorting some of these issues out. Well, I think the RAV4 issue is, I mean, obviously that's huge. It's just that there's so much that's tied in with that. There's so many other issues that are tied in with the RAV. You got the blood, I mean, you've got the, obviously the hood latch, you got the, I mean, you all know what it is. You got everything that's the blood spatter evidence, that's all tied in with the RAV4. So there's so many issues. And then the whole thing about it being staged there, moved there, so it's hard to pick what one of those things would be the turning point. But yeah, there's a whole lot of issues just stemming from that one piece of evidence. Okay, guys, I'm going to wrap it up because, again, tired of hearing myself talk. So, yeah, I hope I covered everything. I hope you have a better understanding, and I hope nobody's freaking out or anything. Trust me, just a bump in the road. I know it seems like we have a lot of them, and we do. But remember, the big issue, the big bump, is this Court of Appeals issue. Not time to panic unless something bad happens there. I don't even want to say it. That's the big issue. Do you get concerned about Uyghur to sheriff with access to the evidence? Actually, no, I really don't. The murder came out 3 years ago. If anybody wanted to tamper with evidence, they would have done it by now. And I don't think Kathleen's too worried about it either, because would she really go and mention that, in a Twitter feed that she knows that the battery was swapped if she thought that, they could go and take it out and wipe fingerprints off it or something? No, I mean, I don't think she's worried about it either. If they could have done something, they would have done it already. The rapid DNA testing is a new form of testing, but it's been approved. It's been approved by the FBI. It's been approved by the scientific community. That's all that's necessary. It's actually not that new. I mean, it's close to a decade old, I believe, but it's just gotten approval from the FBI and from to be used in in a variety of scenarios. Obviously, it was used for the California wildfires, but it's also been approved to be used just in regular law enforcement jurisdictions now. Well, you can never have two 97406s at the same time. Never. That was actually an issue when Kathleen filed her 97406, that she forgot to dismiss Steve's first, and the state jumped all over that and like, hello, you can't have two of them pending at the same time. So you can't have two. I don't know if that's what you're saying, but again, the 97407 is a separate statutory action. Again, it's if Kathleen could do them together, then she would have filed the request to do the testing in with the original 97406, and she didn't. She did the request for the testing first because it's the results that are the newly discovered evidence, not the testing itself. That is something you ask for ahead of time. You don't really care how you got the results. You could tell them, but the results are what are the newly discovered evidence. And again, that's why she stayed away from that phrasing. She didn't want to bring in newly discovered evidence because I think she knew that the minute she mentioned newly discovered evidence, they're going to be like, wait a minute, you can't have this statute attached to that process in the middle of appeal while that case is under review. And yes, I can see the obvious question is, then why wouldn't she be able to remand it? If you have to file a 97407 in the circuit court, why couldn't you remand it to ask to do that? And again, that's because the statutory power of what actions can be taken pending appeal under a motion to remand is that it has to be a specific issue that can basically expand on whatever is already under review. Those bones, that testing was not part of the original action. So that's why it's saying it's a separate thing. The CD was already just expanding on documents, things that were already on the record. It was essentially just giving the court more information to make their decision. And that's why they're saying you can still get this testing done. You just can't do it right now. It's just procedurally not the way it's done. It's off topic, Michelle. Hey, he's been through a lot too. So, all right, I'm gonna wrap it up, you guys, because I like half people have already left. So clearly, I'm not the only one that gets tired of hearing myself after an hour. So yeah, that's always depressing. Like I started losing people after like 20 minutes. So that's why I don't want to do them either, because then it just gives me a complex. All right, so I will talk to you guys later. Oh, the other child's home, so dog is barking. So good time to end it. But I will talk to you guys soon. Bye.